Hi, this is Denny Lee of Lee Law Office in Omaha, and this is another episode of Denny Answers Your Estate Planning Questions. One of the questions we frequently get is how often should we have our estate plan reviewed, whether it's a will or a trust or an irrevocable asset protection trust. And that answer consists of two different components. One, whenever there's major events that occur in your life, marriages, divorces, deaths, new children, new grandchildren, those are always trigger points, in my view, for a plan to be reviewed to see if the plan, based on those changes in the family that occurred, if your plan is still consistent with what your goals and what's important to you are. The second component of that answer of when to review estate plans, whenever we do a plan for our clients, we recommend that it be reviewed every 3 years. Now, we have two items on the agenda at our review meeting. The first item is, have there been any changes in your family that we need to talk about? And if there are, we discuss those. The second element, which is particularly true when we're doing an estate plan, that the foundation of which is a revocable legacy trust, is have you acquired any new assets since the last time we met? And probably about half of the time, we have had clients that have, for whatever reason, changed investment bankers, changed bank accounts, or acquired different assets. And that'll generate a follow-up question from us, which will be, how did you title it? So for those of you that have trusts, you know that the funding of the trust is absolutely critical to keep that particular asset out of probate. So when we prepare a revocable trust for our clients, we also prepare the funding documents. And what I mean by that is, using Bill and Mary as an example, if Bill and Mary had a trust and they owned their house in joint tenancy, they had bank accounts, investment accounts in joint tenancy. Well, those assets on the death of the first of Bob or Mary to die is going to go to the surviving joint tenant. The problem then, as it relates to probate, comes in when the surviving spouse passes. At that point, those assets are owned by the person that died, which is going to necessitate, in most cases, a probate. So we want to eliminate that. We want to see that the assets that are owned by Bill and Mary in joint tenancy are not subject to surviving spouse or a death of a surviving spouse causing probate. So we make one minor change. And that change is simply this. We transfer the asset for Bill and Mary as joint tenants to Bill and Mary as trustee of their joint family legacy trust. And that one step is absolutely critical to keep that asset out of probate. What we have found when we ask that second question on our agenda in the funding meeting is, for those that do answer yes, we've changed banks, we've got a new investment account, I ask how it's titled, about half the time, those people will say, we forgot, we put it in joint tenancy. And that's okay, because what we do now that we know that there's that new asset or assets there, we will give them the document they need called the certificate of trust to take back to the bank and have that account transferred from Bill and Mary as joint tenants to Bill and Mary as trustees of their trust. Now, they both act the same in this fashion. Bill and Mary can do whatever they want with those assets, just like when it's in joint tenancy. But what we're doing by transferring the title to them as trustees of their trust, we are building that protection around those assets to prevent those from going to probate, because we want to stay out of probate. That's one of our motivating factors for many of our clients in doing a revocable trust, is to keep their family out of probate and avoid that time and expense. So thanks for sending us that question. If you have any other questions about estate planning, take a look at our website, leelawoffice.com. You'll find a lot of information and a lot of different resources. If you'd like to call and schedule a time to get together, give us a call, 402-934-4409. You can email us too at legacy@leelawoffice.com. We'll see you next time. Take care.